Hi everybody, this is Professor Couture with a brief introduction to our criminal law class. The things that I'll cover here are the course description, course learning outcomes and skills developed in this course. That includes building career readiness skills. I will provide a cautionary warning on course content, which will be repeated throughout the course as a reminder to be careful and be concerned about issues that may raise some issues for one or more of us in this class, and to understand what you can do when and if that should happen. And then finally, the central questions and the fundamental concepts that are going to guide our work in this course. So let's get started. The course description comes from the course catalog, and that is accurate with one exception. This course will not do a comparative criminal law exploration looking at the development, the origins and sources of criminal law in other countries. I am not sure when that description is going to be changed, but I've looked at the syllabi taught by other faculty here, and that comparative material is not included. We certainly will cover a variety of crimes against the person, violent and nonviolent crimes, property crimes, public order offenses, public morality offenses. We will not explore very much in the world of national security, but we will talk about crimes against government, and we will also certainly cover defenses to crimes, as that is an important piece to understanding American criminal law. You must achieve a C- or above in this course in order to meet the program requirements. So we want to make sure we're off to a strong start and stay strong. And my goal is to help you get strong, be strong, stay strong, and end strong. So what are we going to cover? The first chapter is really laying the foundation for what will follow. So chapter 1 is very different than the remaining chapters in the textbook. The foundational concepts we'll look at in chapter 1 are where and how does criminal law fit into the criminal justice system. We'll look a bit at federal and state criminal law to see that there are a lot of similarities, at least among the 50 states, but some significant differences when we look at federal criminal law. We'll take a review, I hope it's a review at least, of the role of federal and state government and branches of government in the criminal justice system and process. We will look at where does criminal law come from, and that includes state and federal constitutions. The primary or principal source of criminal law is state and federal statutes, laws passed by the legislative branch of government. Those statutes are supplemented significantly in some instances by common law or judge-made law, decisions rendered by federal and or state appeals courts. We won't cover very much on federal and state administrative rules and regulations since they are not a prominent feature in the sources of either federal or state criminal law. We'll then look at how crimes are classified in Massachusetts specifically, but also in general how other states may classify their crimes. The two major approaches are either by subject matter, and that includes homicide crimes, non-homicide crimes against the person, crimes against morality, crimes against the government, property crimes, and a whole range of other things that we'll look at. The second way that some states and many states do classify their crimes is on the basis of the seriousness of the punishment. How serious, what is the maximum penalty or punishment for a person convicted of a particular crime? And every state has crimes that are classified as felonies. In Massachusetts, we'll see our definition is a little bit different than other states. Most states define any crime as as a felony if it is published by 1 year or more in state prison. Anything not punishable by state prison time is of 1 year or more in most states is a misdemeanor. And then there's hybrid crimes that might be, depending upon the circumstances, punishable either as a felony or as a misdemeanor. And we have all three of those categories in Massachusetts. We'll then look at the constitutional limitations on the enactment, passing, the making of criminal law, the enactment of criminal law by the legislative branch of government, federal and state. The enforcement of criminal law, the role of law enforcement at the federal, state, and local level to enforce federal and state laws, and then the adjudication or the court process through which a defendant in a criminal case is entitled to due process and a wealth of protections when they work, which they don't always do. But the adjudication process is through the judicial branch at both the federal and state level, depending upon whether it's a federal or a state crime which is being prosecuted. We'll then turn to why do societies need laws in general, but in particular criminal laws. We'll look quickly at what's the purpose? What are criminal laws designed to do? What are their goals? We'll learn the important distinction between things that are deviant or run contrary to expected norms of behavior in our society versus those things which are not only deviant but are classified and can be prosecuted and punished as a crime. We will see that there are two major types of criminal law. One is substantive criminal law. That is, what is the law in a particular jurisdiction, any state or the federal government, or actually also in the District of Columbia? What does it say is a crime? And how can each of those crimes be punished as a felony, as a misdemeanor, or a felony misdemeanor? So what is a crime? How it can be punished? That's substantive criminal law. Another important part of criminal law is procedural criminal law. That is the process through which law enforcement and courts must follow certain due process and other protections to afford individuals due process of law in the investigation and prosecution and adjudication of criminal law. So there's a whole course on criminal procedure here at Curry. That's the corollary or the procedural criminal law piece. We're here in criminal law talking about substantive criminal law. We'll look at two models of how society determines what should be a crime. Those two models you may be familiar with from your Introduction to Criminal Justice course and or your criminology course. Then we'll turn to understanding the distinctions. What's the same and what's different between civil and criminal cases? And we will see that significantly the differences are the levels of proof and the burden of proof, who has to prove what and by what standard. In our criminal system, a defendant cannot be adjudicated or convicted of a crime unless and until the government proves every element of that crime. Everything the substantive law says is part of that crime, and that proof must be made beyond a reasonable doubt. In a civil case, it could be a jury trial, it could be a bench trial, the same as in a criminal case. The standard of proof is not as high. It is a proof by a preponderance of the evidence. And we'll look at some cases that will help you to better understand the significant important differences between both those levels of proof. We will round out chapter 1 with an important understanding that every crime has what's called 4 elements, 4 things that make up every crime, no matter which crime it is. The legislature, if it's a statute that defines the crime and the punishment, or if it is a common law crime, which is defined by a court decision called common law. Every crime has to have a criminal act generally we think of crime as doing something the law says we shouldn't do. Sometimes there is a duty to act, and the failure to do so might constitute the criminal act. And then, of course, there are certain things that are contraband and it's illegal to possess. The second element of every crime is criminal intent, and we'll spend a fair amount of time looking and understanding at the different types of criminal intent. Concurrence of act and intent is the third element of concurrence of act and intent is the third element, of crime. The fourth element, and I apologize that I'm not sure what happened in this iteration, but the fourth element is called legal causation, and that is whatever the harm is that the crime is designed to protect against. The person who's charged with the crime must be shown to have created that. Okay, then we turn in the remaining chapters, chapters 2 through 10. First in chapters 2 through 2 through 7, we will look at the elements, the criminal intent of selected crimes: homicide crimes, non-homicide crimes, domestic violence, child abuse crimes, crimes against habitation and property, drug and controlled substance crimes, crimes against public justice, public order, operating under the influence. Then we will turn to something called incomplete crimes, where someone either asks somebody, solicits another person to commit a crime, or reaches an agreement to commit a crime, or attempts to commit a crime, but doesn't fully complete that crime. Those early stages of criminal involvement, solicitation, conspiracy, and attempts, are specific types of crime that we'll talk about in chapter 9. We will look at defenses to crime in chapter 8. And then finally, we will look at parties to crime in chapter 10. Individuals whose involvement in possible criminal liability depends upon when they were involved and the degree of their involvement in either a completed crime or in an inchoate crime. So that's our journey. What skills will be developed, or you will be developing and using in this course, include critical reading, written communication, oral communication, information literacy, technology competency, critical thinking, problem solving, and career readiness. And I'll talk about career readiness skills in just a moment. You are not going to be memorizing in this course. You are going to be reading with understanding and then going to the higher level of taking the law as it's given to you and applying it to case exercises. That will require critical thinking and problem solving. Your written and oral communication will be based upon, it'll be evidence-based. It'll be based upon what the law says, not what we necessarily think what the law should be. As part of that, you will be building career readiness skills. Those are what employers tell us are considered essential for being work ready. And all of us, most of us, will either soon or relatively soon or later be entering the world of work, hopefully in a career in criminal justice or a related field. And so building those skills to be ready to enter the world of work is going to be part of your journey with me in this class. And therefore you'll see that the skills that I've called out to be part of your learning in this course are critical thinking, teamwork and collaboration. You'll be working in teams or groups. In class, you can work in teams and groups outside of class if you so wish and organize yourself in that way. I encourage you to do that, but I don't require it. Professionalism and work ethic, I'll talk about in the context of course expectations and policies in this class that are centered around professionalism and developing a strong work ethic, both in the classroom and to carry with you to either graduate school or into the workplace. Finally, what I want you to know is that everything that we are going to cover in this class in terms of the content of criminal law relates predominantly to one of three questions. What crime has been committed, if any? Has a crime been committed? What is it? And part of the answer to that's going to be taking the facts that are given to you in case scenarios and saying, well, given that this happened, that would help the prosecution prove this element of the crime. And we'll get lots of practice on doing that. Lots and lots and lots. What defense, if any, is available to either excuse or justify the defendant's conduct. So all of Chapter 8 will cover either justification or excuse or procedural defenses to a crime, which says, well, maybe you can prove that the defendant engaged in the conduct that's the criminal act with the necessary, or maybe with or without the necessary intent, depending upon the nature of the defense. But there is in the law a defense which might either totally excuse and exonerate the defendant, resulting in a not guilty verdict, or at the very least may result in a reduction in the seriousness of the charge for which the defendant is convicted. And then we will finally be wanting to look at, okay, so a crime may have been committed. Maybe there's 4 people involved in a burglary into a liquor store to steal liquor. There's the person who plans it, calls everybody up, gets everybody together, says, all right, you're going to come. This is what we're going to do. You're going to be the lookout person. You're going to be the getaway driver. All of those people have criminal responsibility. Maybe if someone helps and provides them the code to get through the security system at the liquor store, that person could be charged as an accessory before the fact to the liquor store liquor store burglary. Maybe they dispose of something they get at the liquor store or the getaway car and ask someone to hide it so as to impede law enforcement's ability to investigate the crime and make an arrest. That person could be charged as an accessory after the fact. So everywhere we go in this course, everything that we're going to talk about, beginning in Chapter 1, which is all the things that I just went through, which are listed here, and then moving to the fundamental concepts and looking at the elements of each crime, each homicide crime, murder and manslaughter, and there are variations of both in most jurisdictions, including Massachusetts. We'll look at what's the criminal act in a murder, what's the criminal act in a manslaughter, what's the criminal intent, and what we'll see is often the distinction between murder and manslaughter, not always, but often centers around issues of the defendant's criminal intent. Concurrence of act and intent, we'll talk about what that looks like. And that basically means if I intend to kill my husband next week, and today while I'm driving with him to the grocery store, I get distracted, swerve, and hit a tree and kill him, I have not murdered him. My intent to kill him does not coincide with my action of driving into the tree, at least so far as that driving into the tree is either reckless or negligent, but not intentional. And then causation is going to be a factor in every crime. We'll look at the types of crime: homicide crimes, non-homicide crimes, property and habitation crimes, some other crimes against public justice, against public order, drug crimes. We'll also look at operating under the influence crimes and inchoate crimes. And then we will look at a host of defenses to crime. So that's where we're going, and it's going to be a good ride. So please let me know how I can help, and feel free to reach out to me for any questions you might have. My goal is for you to enjoy the class, to work hard, to learn a lot about criminal law and about yourself as a criminal justice professional or aspiring criminal justice professional, and for you to be successful. So let's work together. Thank you.